Good morning, good afternoon, good evening to everyone, depending on where you are joining us from today. I would like to warmly welcome you to today's webinar. This is the fifth edition of the Set Perspective webinar and the first for 2026. Today, we will be delving into a rather important topic on data protection and privacy in environmental assessment practice. We have a speaker from the Data Protection Commission who will be taking us through this topic and sharing some very important insights as to how we manage data in our work as environmental assessment professionals. Before we start, I would like to go over some basic housekeeping rules so that we can ensure a smooth and productive session today. And so please kindly take note that the webinar is being recorded as usual, and we will share the recordings on our YouTube page over the next few days. We will also be able to take your questions during the Q&A section at the end of the session. So if you have any questions, you can either put that in the chat as we go along in the webinar, or you can wait during the Q&A session where you use the raise hand function, and we will call you to ask your question. Please take note that we will only address questions during the Q&A session. So please kindly note all your questions down as we go along. Like I said, we would ask that everyone kindly keeps themselves muted, and during the Q&A session, you will be called to speak. So by remaining in this session, you consent to be recorded, and so if you ask any question or anything, please kindly note that it would be part of the recording that we will share onto our YouTube page. Thank you very much for kindly adhering to these few rules. Like I said earlier on, we are joined today by Mr. Kwabena Otridia from the Data Protection Commission. He is a Data Protection Compliance and Impact Assessment Officer at the Commission, specializing in data protection compliance, impact assessment, and information security. He also has a very strong background in cybersecurity and AI. AI is running the show these days, and so it's quite, that's a very relevant experience that he has. His expertise also includes developing and implementing data protection frameworks, conducting privacy and impact assessments, and ensuring alignment with regulatory requirements and industry best practices. And so today, we are privileged to have him here with us to share very valuable insights and also practical perspectives and actionable guidance to help us in our work on using and managing data. Mr. Dia, is there any few words you'd like to say at this point before we move on?
All right, thank you, Madam Iroma. I'm fine. But it's a great honor and also privilege to represent the Commission at this webinar. And kindly permit me to appreciate the organizers for extending an invitation to the Commission. And you're also doing a good work where you're actually creating a platform to bring together all practitioners within the environmental protection field. These are expertise in whatever they do. And the Commission being present today will actually outline the rules and mandates of the Commission, what the Commission expects individuals and organizations to do as processing of personal data is concerned. So it's a privilege to join you guys today, and I really appreciate it. Thank you.
Okay, thank you very much. So now the purpose of today's webinar is to basically build awareness and practical understanding of data protection and privacy obligations as they apply to environmental and social assessment practice. Now, today's session is to help all of us as practitioners to handle stakeholder data lawfully, ethically, and responsibly during project planning, assessment, reporting, and monitoring. And I have just remembered that I did not introduce myself, so kindly forgive me. For those who are regulars on our webinars, I'm sure you know who I am, but for our new participants, Irama Kakraba Ampe, consultant here at SET, and I will do my best today to guide us through this session. So now in our work as environmental assessment professionals or environmental management practitioners, we routinely engage with communities and individuals as part of project planning, impact assessment activities leading to decision making for projects that we work on. During stakeholder engagement and public consultations, we routinely collect certain data, a lot of it being personal data that we then use in our assessments. A lot of the time, this data is then put into the reports that we prepare to submit to regulators. Some of these data may include names, phone numbers, photographs of stakeholders, of communities, of individuals. And now, in the age of data that we are in, it is very important to use and manage the data as professionally as we can to ensure that we safeguard these individuals that we collect data from. And so, with that in mind, today we'll be hearing from Mr. Dia, who will give a presentation on what we ought to do where data protection is concerned, as far as the data that we collect in our work goes. And so I will hand over to Mr. Dia to kindly give his presentation. And then afterwards, we will have a bit of a discussion, and then we'll open the floor for any questions. Okay, thank you. So, Mr. Dia, over to you, please.
All right, thank you, Madam Irama, for the quick introduction, and also thank you once again for inviting us. And I also acknowledge all participants and practitioners actually being on this meeting. So I'll be sharing my screen so that we dive deeper to the requirements of the commission. I hope you can all see my screen.
Yes, yes, please.
Okay, so data protection awareness today. When it comes to data protection, we have a whole lot of explanations when it comes to this particular terminology. But then, what is data in here first? Because we have data, as you mentioned earlier on, we have statistical data, we have administrative data, we have finance data, we are having research data, we are having predictive analysis data, and all sorts of data. But then, what the commission stands in for as data explains the information that identifies an individual. That's what the commission stands in for. So the commission is a regulatory body that's being governed under the Act 843, which speaks to the commission having the full mandate to processing and protecting the personal data and privacy of every individual. Not just that, we also seek to it that institutions, practitioners, individuals, as ourselves here present, will use the proposal that will be more stringent and appropriate on how to obtain data, how to gather it, how to retrieve it, how to disclose it, how to store, and also under it at safety seeks to it that every individual that has the possession of personal data will pass through the appropriate measures in processing personal data. Mostly organizations say that, okay, I am registered with the commission. That makes me compliant with the commission. That's not it. In the presentation and submission of Madam Irama, she made mention on some different processes and activities that environmental practitioners undergo. So today we are going to use the mandate of the commission, compile it up, merge it within whatever operation you do, and also align you to the practices that are best and also favorable within the Act 843. So now this is what a commission is about, and this is what we are going to dive into today. So now the topic today is what is next after registering with the Data Protection Commission. I wouldn't speak much about the registration. I'm sure it will come into a question. So we'll leave that into the comment sections. Then we'll talk about the data protection registration framework. So now on the next slide, I don't know if this is going to be an open forum. When it comes to data protection, what comes in mind? Somebody approaches you and just asks you, what do you know about data protection? I know most of us are going to say, okay, it's me keeping my information safe. How are you keeping your information safe? That's me having passwords and also not posting things that are more personal to me. Others will also say that I wouldn't have to be out loud with my information out there. I have to be more confined. I have to be protective. I have to be hiding. Whatsoever meaning that comes into our mind, that is true. But then, mind you, knowing that we are practitioners, organizations that handle processing of personal data, we go to the extreme mile of actually going outside the jurisdiction of the country, going to other countries or jurisdictions that are also processing personal data. So when it comes to protection of personal data, is protecting the information that we are processing within our organization, whether be it manual processing, whether be it online processing. The commission seeks to it that we have to use the appropriate measures and technical measures on processing personal data. Now, within the Act, that's at 843, we are having some terms where the commission use. So, as a practitioner within the data protection field, these are the terms that you'll be using. Should in case you are being trained and also registered under the Act, these are some terms that you have to be conversant with and also embrace yourself with. I know with the environmental practitioner field too, you're having an act that covers you, and I'm sure you're having some technologies that also guides you in you establishing your processes. So with the first term here that we are going to identify here is personal data. So what's personal data? Personal data is an
Sorry,
identity.
Mr. Dia, sorry to interrupt, but if you have moved on from the slide two, we are not quite seeing that.
Oh, you're not seeing it.
Yes.
So what are you
Okay,
seeing?
now, yes, now we can see. Now, oh,
Yeah, probably.
oh, okay, yes, yes.
I'm sure it might be the network. Sorry. So what do you see?
No,
Definitions of terms, right?
yes, definition of terms. Yes.
All right, sure.
All
So
right,
as I was
thank you.
saying earlier on, you're welcome. As I was saying earlier on, within the Act 843, these are some terms that we actually use in our day-to-day activities. We are having personal data, we are having processing, data processor, consent, data controller, and a data subject. So now, what is a personal data? A personal data here is an identifier. It's an attribute that uniquely identifies an individual. So now it can be your name, it can be your email, it can be your number, it can be your house number, it can be your SNET number, it can be your Ghana card number, it can be your passport number. So these are information that uniquely identify you. Should in case someone else on this meeting is also called Kwabena or Chidia, as myself, what is uniquely going to identify us as two individuals. Now, outside the name, we are now going to go further to look at our contact number. Are these contact numbers the same? It wouldn't be the same. We're going to have two different contact numbers. Is our Ghana card the same? It's not going to be the same. It's going to be two different numbers. So under personal data, we speak to something that uniquely identifies you as an individual. We'll move next to processing. Processing here is a term that is being given to every set of activities that is being embarked or done on a personal information. Someone might say, I'm not processing any personal data. So then why do I have to register with the commission? But processing here under the act is any set of activities that are being conducted on the personal data. Mostly, organizations actually identify processing as hosting. That's me storing the information. But then you having the information on a paper is also processing. You even transferring it to another individual is processing. You viewing it and using it for any other processes is processing. So any that is being conducted on the information is what we term as processing. Now we'll go to a data processor. A data processor here is an individual, an entity, a sole proprietor, or jointly connected individual that are being appointed to process personal data on behalf of a data controller. So now a data processor is being appointed on behalf of a data controller to process information on their behalf. Within this term, we are going to have examples where we are going to merge them into. So don't worry about it. You get to understand it when the examples comes in. So now a data subject here too is you and I. You are a data subject to your organization. I am also a data subject to my organization. Any other service provider that is actually processing our information, we are data subjects to them. So a data subject is an individual that provides our information or their information to an entity, to an individual to process. Now, a data controller here is who has the full mandate, purpose, and manner at which information or processing should be handled. So here, a data controller contracts a data processor to process information on their behalf. For instance, with environmental protection, you are having agencies within this particular ecosystem. So for you to go to the field to collect information from whosoever you are collecting it from, you are going to use systems to actually process this information. And I know within your mandate, you also make this information public to other agencies, to other regulators, and to other consultants who will be actually requesting for this information. After you are done sorting out this information, you don't have any medium to transfer this information to the parties or stakeholders that are involved. So now you are now going to go in for a transmission medium. You're now going to go in for an email. You're now going to go in for a telco to actually register you to send broadcast messages. What sort medium you're going to use, that particular entity now becomes a data processor because they are going to process it on your behalf. I know we are going to ask questions. Are my employees data processors? No. Employees are not data processors. Employees within an institution, they are termed as data recipients. So they see, retrieve, edit, delete, alter information within an institution. So employees within an institution, you are a data recipient. But then a processor here is someone who is being contracted on behalf of a data controller. Consent. I know in our day-to-day activities, consent is also something that we all say, yes, I've seen consent from the data subject, I've seen consent for the community members, I've seen consent from this and that. Let me cite an example with our earlier on engagement. Before we all logged onto this application, we had a pop-up menu that informed us that we are actually going to record this session. But later on, Madam Rama made us understand what will actually come out of this particular recording. So the implied consent taken from the initial process is not the same as the consent that should be taken for other engagement that's handled behind the scenes or after the meeting. So consent here means you have to be clear on every decision you are making or information you are taking. You have to be informative. It shouldn't have any other alternative meaning and have to be clear, specific, and evidently proven should in case there's an issue. You seek consent from a subject today. Tomorrow you are using it for other processing. The commission does not allow that, or that is not consent. So every set of activity, every set of processing that you are using this information for, you have to seek a new consent. So that's for the definition of these terms. Now we'll move on to what is next after registering with the Data Protection Commission. So under the data protection, we are having functions that actually mandate us to establish within this ecosystem as processing of personal data is concerned. We provide monitoring and compliance to the Data Protection Act, so the organization will actually adhere to the practices within it. We also do audit and investigation. We train professionals as we are to help organizations to establish a full mandate of the commission. We also guide institutions on how to go about with the processing of personal data. And we also have the mandate to also publish a register to let the public know that these are the organizations that are in full compliance with the Act 843. So now, after registering with the commission, we seek that you train your employees on data protection rules and how they apply to your company and their rules. Right after registering with the commission office, we'll be speaking into it. You have to train your individuals, the staff members that are in there, on the appropriate measures on how to process personal data. Mind you, an employee may be in the organization and wouldn't know how to process personal data here. Within our ecosystem, we are having personal data and also we are having another category of information that speaks to sensitive processing. We'll come to that side. This information, regardless of how you collect it or how you obtain it, you have to use the appropriate measures to process them. Someone might say the information being a name and a contact number is normal. Everyone needs it. But then if you are not processing it well in appropriate measure, you can actually lead to a breach. And these breaches are going to lead you to a conviction of which the act also speaks to it in different session and different mode pertaining to the breach that has actually happened. So the commission expects that you have to train all your individuals, and we are having specified training that actually appoint a data protection supervisor under our section 58. So now, two, after registering with the commission, you now have to prepare data protection policies, procedures, and ensure they are communicated to and attested by the employees and relevant sub processes. So under our Data Protection Act, we actually mandate that every organization will have a data protection policy. And this policy, aside this, will have other policy. You can have your privacy policy, you can have your risk assessment policy, you can have your information security policy, retention policy, SLA, third party vendor assessment risk policy. These are data subject access requests. These and other more policies are what the commission mandates and also require that organization will actually establish. Know that you registering with the commission does not fully give you a compliance approval. You have to work on these protection policies and also some other measures. So should in case later on there's any issue within your organization, you have to defend it with these policies and procedures to make the commission more informed that yes, if every information you are processing is in good hand and in good standing. So step two, you also have to provide an appropriate regulatory requirement that mandates you or allow you to process personal data. I don't know for the environmental protection how long we are allowed to hold personal data, but under the AML, under the Intelligence Crime Bureau, under the other regulators, at most you're supposed to hold it for 6 years. Then if you're having the strength to hold this further or more, then you have to defend it. That's where your retention policy will come in. Within your retention policy, all information access systems that you're having there, you have to align or subject them to a retention period. Because you hosting or storing information for longer period of time can also lead to a breach where should in case you are being hit today, you wouldn't know where to start from. So you also have to keep records of processing activities under our section 24. Please, if you have any other question, kindly draw my attention. If I'm moving fast to you, let me know, please. So now on step 4, we also offer easily accessible breach register. You as an organization have to do this within your organization. So if there should be any breach, you have to record it and report it to the commission. As soon as there's a breach, the first thing for you to do is to know how to contain that breach. You should know how to prevent that breach from escalating. to know how to prevent that breach from expanding to other measures. Then, if it gets to a state where you feel you are being overwhelmed, then you have to invite in experts, the commission, and also some other parties, as the police, the investigative committee, to actually come in to assist you in this particular investigation. And if you don't have a breach register, and the commission should come to you, and the first question you're going to ask is, how did you know, or how did you identify this breach? Then that's where your register comes in. Because you're not now going to go through a whole lot of procedure. You having that register will be a first point to the commission and also any other investigative personnel in helping and assisting them to know how you identify this breach. And with this breach, you have to include them in your basic privacy assessment. The policies I mentioned earlier on, you have to get all of these things included when you are being registered with the commission. Now, this is the main topic that we are going to speak to: compliance. So now, with the registration procedure, after you are done registering and you having the certificate of the commission, how do I stay compliant with the commission? So from step 1 up to step 5, we are going to summarize it here and also outline it to the environmental protection activities. So for instance, I am a consultant where I step out to a community to take information on them. First and foremost, within the act, we are having 8 principles where we speak to lawfulness of processing, we speak to specification of purpose, we speak to further compatibility processing, we speak to quality of information, we speak to data subject participation, we speak to data security safeguard, we speak to accountability, and also speak to openness. So within these 8 principles, as an environmental practitioner, I am moving to community A. What am I going to do? I am going to collect information to check on the climate issues, to check on natural disaster issues, to check on housing issues, to check on forestry and other activities that might influence the environmental state, for me to decide and to provide solutions to it. I move to party A. Before going there, I didn't inform anyone, I didn't inform any individual on how to go about with this collection. I just have in my hands some souvenirs, of which I know that if I give these souvenirs to these individuals or data subjects, they will actually give me this information. Within the act, under accountability, you have to be liable to every information that when you are processing it, you're not going to infringe on the privacy of the individual. So with that particular approach, first you have infringed on the privacy of the individual, trying to make an implied or a decision that wouldn't favor the subject but will favor you. So the commission is saying that for you to even step foot within that particular community, you have to get your legal basis for processing. Legal basis here is that you have to have the appropriate legally binding procedures that will back you for every information you take. So now you might defend it that okay, under the Act, Environmental Act, we are regulated or mandated to collect this information. That might be true, but then outside the mandate of the act, you as a practitioner have a responsibility to play here. You have to inform the data subject. So that's where consent comes in. You have to let them know why you are taking that information, what purpose is actually going to be sought for, who is going to have access to this information, where is it going to be hosted, how long am I going to hold this information, and when there's a time for me to get rid of it, these are the measures that I am going to what discard it. You might say it's a whole lot of process, but then a subject can give you their consent and later on withdraw their consent. If you are not able to withdraw that consent appropriately and these issues keep on happening, you will be liable to convictions and also a breach as the Act 843 is concerned. So under consent as a legal basis, you have to be more clear and specific to each and every subject that you are taking the information on. Should you take information for the purpose of knowing housing effect, knowing environmental effect, then later on you use it for analysis in marketing purposes, where you are going to use these individual pictures for your website marketing purposes, for your newspaper marketing purposes, that is a breach under the act. Why? Because for the initial purpose where you process the personal data, it was solely to help them or you to know the housing practices or the climate exchange. But then to use it for marketing purposes, to use it for broadcasting of messages, to use it for analysis or predictive whatever you're going to do, that's a breach under the act. So if we are seeking consent from a subject, kindly let it be clear from onset, document it well and keep it. If you are having a manual form of keeping it, we advise that you also have an electronic copy, just in case the commission comes and asks, who are these people that you seek their consent with? You can evidence it and also let them know that this is what you told them. So under the lawfulness of processing, we have consent, we are having contract where your employees might come in, contract where your subject as a consumer can also come in. So you also have to know if it's in the public interest, if it's in their vital interest, if whatever you have seen is explicitly going to inform them. That's where sensitive data comes in. So with the sensitive data here, the information that I as a data subject wouldn't be willing to provide to you upfront: my race, my political affiliation, my sexual orientation, my ethnicity, and some other stuff. If I'm not welcome to provide those information to you, and you need it for the purposes of your practices, you have to clearly and inform me best way that you can to actually provide it to you. And when it's being provided to you, kindly keep it well, because if there's any hit on that, you actually be held responsible. So now with the information that you are taking to, you have to give the subject a means and a way to opt out should they not be willing to use their information for any other purpose outside what you communicated. You have to give them a channel where they have to opt out. That's where the data subject participation comes in. You have to give them a way that they can actually opt out from this particular mechanism. So if you could see our website, we have cookies, preferences, and other stuff. When I go to your website, upfront, you're having a cookie display to me that due to these preferences, I have to accept this and that per whatever regulation that governs your website. I can decide to choose none, I can decide to reject it. There you have a record of it. But then you should not have an implied consent where you already accept me and require that every other automative processing that happens within my processing on your website is allowed. But the commission speaks against automated decision being made on a data subject. So now staying with compliance with the commission, you have to know the legal basis that you are processing personal data. You have to inform the data subject. You have to limit the processing of personal data that you are actually going to publish out there. And the commission speak to it that when you are publishing information of an individual, you have to anonymize it. Anonymizing here means that you have to turn it in a way that wouldn't identify the individual. So it wouldn't have to be irreversible. So if maybe you have taken Kofi Mansa is in house A, Kofi Mansa has been diagnosed with ABCD. Kofi Mansa have family of that. Going to another house, you're having Amma Mansa. Within that particular publication, within that particular information to be made to the public, you have to anonymize those data sets so that it will not trigger or be identified to the individual or to the community where you are going to have that publication being done on. And if you are going to share it with any other party, whether it be a regulator who has requested for it, whether it be a consultant who has requested for it, whether it be a practitioner who has requested for any stakeholder that will require of you to send or share information with them, you as a controller, as a practitioner, you have to have a responsibility. Now, that responsibility here is that you have to ask them, what purposes are you actually seeking for this information? If they are able to defend that purpose, now you let them know, I have a whole lot of data set on this individual. What are the actual information that you need to process the information? That's where data minimization comes in. You have to provide or process the actual information that are relevant and also of need to whatever information you're having. So probably you need the count of individuals in a community. You need We are providing them with housing effect. You need not to have the names of these individuals, the numbers of these individuals, their sexual orientation, their marital status, their financial information, their employee status. All of these things wouldn't need for you providing a house structure to your subject. So all that you have to do as a practitioner is to let them know, okay, these are the data set. And within this data set of community A, there are 50 individuals here. These 50 individuals, amongst 5 of them, they are having a low budget building. Amongst 10 of them, they are having a moderate housing effect. 50 of them, they are having a more appropriate and quality effect of housing. That is actually going to be a way of you securing the information you have out there to whoever is asking. Because if there should be a breach, the first trace will come to you, a practitioner, a consultant, or an entity as the data protection is concerned. Should in case whoever you are sharing that information with has third parties, you have to do a third party risk assessment on them to know that whatever information they are taking, they are not also going to use it for any other purposes. You understand? So you have to be very clear and informative of every information and every individual that you share your information with. And within internal procedures, you also have to provide measures in place to safeguard this information. Should there be an employee sending a list of information out there, they have to be trained to know the actual information that should be shared with these parties. Would there be a need for them to request for a whole lot of information? You can actually do it read only in a way that they cannot download the information, in a way that they cannot alter the information, in a way that they cannot use for any other purpose. At that particular point, you have done your work, and if the commission should come after you, you are safe to go. And under the act, we are having convictions where you can visit our section under 56, 80, 89, and 95. The highest penalty here is 5,000 penalty unit, and you can also serve a term of 10 years and more if there should be any breach within the processing of personal data in your system. And also, we do not require that you will buy or sell information from or to any other individual. So, stay in compliance with the commission, we require that under the principles, whatever solutions you are processing, you have to identify the categories of personal data. You have to get the information that actually handles the processing. You have to inform the subject. You have to let them know how long you are going to keep the information, who you are sharing with, and also the security measures to be implemented in this particular processing. So that's how come you are going to be compliant with the commission. And in saying all of these things, you have to defend it. That's where the policies in part 2 comes in. You have to provide all of these data protection policies and procedures to actually defend your compliance status with the commission. Now, coming to the last part, we have to conduct anonymous staff surveys to, review your internal procedures. What are the loops and gaps that are being identified? Because for you to do a risk assessment on a system, you actually have to get that feed from the individuals that are actually having access to that system. They know how they are processing the information. Don't just go to IT that, oh, IT handles the system. So no, IT will come into play. But then the individuals that interface the system, you actually have to get a way to take information from them that will actually help you in updating your system and also safeguarding personal data. So these are the procedures and requirements that as a data controller, as a data processor, will have to pass through to be in compliance with the commission. So now having here, this is what you will be having when you register with the commission, and also you are coming to do a renewal. So you have to appoint a data protection supervisor where you have to pay. It comes at a fee. You actually have to book for it. You appoint an individual within your organization. You appoint the individual to the commission. The commission will treat them 5 days. At the end of it, you are being given a certificate to handle the processing. You have to get your basic privacy assessment done. That's your data protection policy, privacy policy, consent management policy, DISA, your risk assessment, information security, cloud security, SLAs, third party vendor assessment policy, risk assessment. So you have to get all of these policies ready before you come in for your compliance journey. You have to document all of your privacy risks, probably as an expert on the field. When I'm done taking the information from the subject, how do I transport this information? Do I keep them in a bag and take it home? Do I give to a delivery individual to deliver it to our organization where another set of recipient will work on the data? Any other processes that you're actually establishing or being embarked on, you have to identify the privacy risk. That's where impact assessment comes in. So impact assessment, that's the deep PIA, data protection impact assessment. That's where my field comes in. We'll do a thorough and more investigative process analysis on your system, where we are going to go outward to each and every party that you are having this engagement with. We are going to assess your service level agreement. Some organizations will go into a contract where they do not check the dispute resolution clauses, they do not check the liability clauses, they do not check the termination clauses, they do not check the data protection and confidentiality clauses. So as soon as they are trying to terminate the contract to go for any other contract, that particular service provider or vendor can state to it that they are holding the information and not giving you access to it. Why? Because you thought that the information was for you, but know that the medium that you are using to process was not for you. So out of the contract, you have to know what will be more convenient and safe to you as a data processor and also as a data controller. So these are the steps that you have to pass through when you are registering the commission. And as a participant of the environmental field, we seek to whether you pass through the appropriate and procedural measures on protecting and also enhancing the safeguard of personal data. So that will be the end of my presentation and also a summary of what the data protection expect every stakeholder, every individual, and every organization to establish it. Thank you. So if you have any other questions, I'm sure Madam Rama will be facilitating it from here.
All right. Thank you very much, Mr. Deere, for a very in-depth presentation. Personally, I have learned quite a lot, and I'm sure our participants have as well, particularly with what you shared around consent, and also the retention period for data, how to ensure that the data is safely managed and safely stored, and also safely shared. And so at this point, I would like to remind everyone that if you have any questions, kindly drop them in the Q&A section using the Q&A function, and we will address all of your questions. But before that, I must say, Mr. Dia, you have actually touched on a lot of the questions that I had for you in your presentation. So you have made my work very easy today for me. But beyond that, I think one thing you mentioned, which I'm sure will be on the minds of participants, was around the publishing of data. Now, in environmental impact assessment, the data that we collect, which usually would be things around, names of stakeholders that we consult, where they work, if relevant, their position, their contact information. So this could be phone numbers or email. We collect all of this so that we can show evidence of stakeholder consultation to the regulator, that is to the Environmental Protection Authority mainly. Now, during the preparation of our reports, we include this data, also including pictures of the individuals that we consult, those that consented to being taken photos of. We put that in there to satisfy the requirement from the EPA as to the fact that, we actually consulted stakeholders. I'm sure oftentimes some people, somewhere can just cook up certain consultation information on their desks. And so this is a way for EPA to actually check that consultants do consult stakeholders. And so how do we sort of balance this need for showing evidence with what you were saying about sharing data with third parties, including regulators?
Okay, thank you, Madam Irama. So, when it comes to sharing of information as an impact assessment officer and as a compliance officer, mostly you have to get a binding clause that will actually save you as a commission or sorry as an organization, because here being the case the regulator needs it for a purpose where they are legally obligated to do that. But then know that outside the legal obligation, you as a controller, you also have a responsibility to play. So right now the regulator needs it to actually defend or approve of whatever consultation or assessment that you have done on behalf of a particular community. That is fair enough. But then the next question that you have to ask yourself is, how am I sharing this information with them? Is it a manual procedure? Is it an online procedure? Within these two medium that I have mentioned, what are the appropriateness of me sharing it? Can the regulator have full access to this information? Can the regulator mandate or alter this information to its purposes? Regardless of it being a regulator seeking for information from you, the regulator also have a responsibility to process as this personal data is concerned, because here consent here is going to be less because the regulator has requested for it. It becomes a legal obligation. So regardless of whoever is seeking this information from, you have to get a binding clause between them, a data processing agreement, an addendum, an information sharing agreement between the parties, MOU or whatsoever it should be. As an organization under a ministry, you will know how to process this information. If it's going to be extensive enough for the regulator to request for this information, you can actually find a way to anonymize the information. So if probably the name, the contact number, and other information are being shared, as a practitioner and also a regulator, you can ask the regulator that with this information that we are sharing with you, it is too much, it is very extensive, and it wouldn't play a full relevance to the processing or the purpose of you sharing. So what you have to do to let the regulator know that within this timeline, what are the exact information that they will need to actually confirm that you did a legit consultation. The regulator can also go back and also do their assessment on these communities. That can also be a way where the regulator can use this data set that are being provided to you. But it wouldn't have to be necessarily that the regulator is going to ask each and every individual, because first and foremost, it wasn't the regulator that took the information. So now the processing agreement is now going to bind you and the regulator to know how you are processing the information. So first, you have to inform the regulator the purposes of which they are collecting this information. What they are going to say that they are going to use this information for the purposes of defending that you did a consultancy that is legally approved. Outside that legal approval, you can also anonymize the information. That's where you are going to limit the information provided to the regulator. You'll be surprised that all this information you're giving to the regulator, it wouldn't be needed. But the regulator will be needing some actual information to defend whatever consultancy that you have done. But since you've not asked and since it's a regulator requesting for it, you find yourself in providing all of this information. But under the data protection requirement, as a data controller, you have the full authority and mandate over this information. And you can also decide on how to share this information to be in favor of you. Don't know if your question has been answered.
Yes, I think partly, and I think that is because I sort of left out a bit of context. So, with the method of sharing this data, the EPA requires that this data is actually put into the environmental reports, environmental impact statements that we prepare, and then these then become public documents. So, I mean, with that additional context, does that change anything? Because the LI 2504, which is the Environmental Assessment Regulations, actually does specify the type of information that should constitute evidence of stakeholder consultation, which I mentioned earlier would be names, contact details, etc. So does this change anything still with regards to your answer?
So, with processing of personal data, an individual may see this as a breach, an individual may see this not to be a breach. All right. So the commission can actually come in to prevent this from happening when a data subject requests or files a complaint to the commission. So now, with every information that you are putting in the records, from where I sit as an impact assessment, it is very excessive because this is a report where you are going to publish to the public. Are these names, these contacts, pictures actually going to be of interest to the public? These are some questions you have to ask yourself because these are legal processing that you have to pass through. It is actually going to be in the public interest to process this information. Within that particular report, we all know that report is a summarized version of whatever sample that you have taken. It's not going to have a whole lot of information in there. We're actually going to summarize it. So if you are doing a summary of report where it has to confirm your consultancy engagement, are all of these information relevant to be included within this particular report? This is a question you have to ask yourself as a data controller. So from where I sit, the first thing I'll ask, outside the legal obligation, what are the responsibilities between these two parties? What are the agreement of sharing this information? That will be the next question I'll ask. If such agreement is not there, their legal basis will now have to be defended per MOU, per whatever contract binding that they are having. If that is not able to be provided, then that particular report will have to anonymize the content of information that it has because the whole information in there is not going to serve the public right. But then, per an individual seeing that report might raise an alarm and report to the commission. The commission will take it on. So before we even stop any other processing like this, we will have to now do our investigation before we come out with a verdict. So as I'm saying right now, it's between consent and regulatory obligation. So now outside this, that's where further investigation are actually going to come in as the commission is concerned. So what I will say is that you can actually pitch it to your regulator and let them know with this information that they are requesting to be placed in this report, is it going to be of benefit to the public interest? And you taking the consent from the data subject, did you include it clearly that their information will be included in a report and also published? If you didn't do that, then you breach the Act 843. So you can weigh from different angles. So as an organization, as an entity, as an individual, you have to do the privacy risk assessment before you even go about with you processing, sharing, holding, or even destroying the information that you have in your systems or processes.
Okay, okay. Thank you very much. Now just slightly moving on to the bits about the retention period. I think as far as I am aware, the EPA does not necessarily prescribe a period for which we, as consultants, can retain the information that we collect. You mentioned 6 years in one case for an institution. Is there a recommended sort of number of years or months or weeks that a firm or an organization can typically hold on to data?
Okay, so as I was saying, per regulatory standard, it's actually 6 years in Ghana. But then Outside the 6 years, if the organization can handle the holding of personal data as long as they can, you have to actually evidence it and prove it. That's where your retention policy comes in. So if you want to hold it for 10 years, you want to hold it for 20 years, you actually have to have a retention policy. And you know that we are having pride when it comes to public organization. Within pride, too, they are having a stipulated set of period that you have to hold information. That is somewhere 5 or 7. So within that particular period of time, if you feel you can hold it to an extent, you can keep it. But then you have to evidence it to Prad or also the commission that these are the measures I'm putting in place. Because you holding that information is also leading to a security implication. Because if there's a breach now, the information that you've held for how long you are holding it for can actually be in the custody of every organization or every expert who is a fraudulent or who is an attacker, and that is going to be an issue to you. So if you can defend your retention status, you have to document it and make it a policy to keep you binding to that. And you hosting it or retending it, or let's say saving it alone, is not something you just have to do. You have to now defend it with the appropriate security measures on how you are saving it, whether on-prem, physical service, whether cloud infrastructures. You have to evidence it. And if you are saving it in cloud infrastructures, you have to do your third-party risk assessment work. So it's from one layer to another layer. So if you are holding a data for a particular period of time, you have to get other policies to support it. So the commission is not going to stop you to have a stringent 5 years, 6 years, 7 years, but then you have to defend the years at which you are going to hold that particular processing of information.
Okay, okay. Thank you very much. So now we would move on to the Q&A session where participants can ask questions. There are already a few questions that we have in the Q&A section and also in the chat. And so I will ask these to Mr. Dia as and when they have been asked. And so the first question is from Mr. Aaron Asante Adai. He actually has two questions. The first question is, do firms and also individual consultants have to register with the Data Protection Commission? And also, are consultants required to have a signed document that states that stakeholders have been consented to be interviewed? Is there a standard form for that?
Okay, so to the first question, under our Act Section 27, if you have the intent of processing personal data, then you are liable to register with the commission. So whether be a consultant, whether be an entity, whether be a sole proprietor, if you have that intent of processing personal data, then you are required to register with the commission. So here, since we are all having personal data as an entity, as a legal binding corporation, you have to register with the commission. With the registration requirement, I want us to finish, then I will take us through it so that we wouldn't actually have to be. So since you are processing personal data or have intent of processing personal data, you have to register with the commission. And the second question, under the consent framework, the commission is the regulatory body that actually approves on consent. So regardless of every framework that you are having, the commission will have to approve on that consent form way before you can even use it. And our new bill will be passed, where we will bring in directives and also some other procedures for organizations to follow. So yes, very soon the commission will bring in a standardized requirement where it will have to involve in a legitimate assessment criteria on the consent that you are actually taking from the data subject.
Okay, I think there's also a linked question to that. I think someone asked if verbal consent suffices.
So verbal consent, how are you actually going to document it if the commission should ask? Are you going to record it? If you are going to record it, how safe are you going to keep that particular consent in there? If you are using a video, How safe are you going to save that particular consent? Where are you going to host it? Where are you going to save it? So outside that verbal, whether audio and whether being video, you have to document it. One, two, it has to be readily accessible and available when the commission should request for it. So in any mode that you use for your consent collection, all that the commission states is that are you actually explaining clearly to the data subject on why you are taking this information, what you are going to use it for, how long you are going to keep it. So if you're able to check all of these things and the subject approves of it, whether being an audio, whether being a check in, check out, whether be a video, you have to document it well for it to be presented to the commission.
Okay, thank you very much for that. I think there's also another question from Aaron. I think this is still linked to what I was asking earlier about data shared in EIA reports that are published by the EP and then become public. So he's asking, would consultants be held liable for information shared in EIA reports? How do we balance liability between consultants, between the regulator, even between the project proponents?
Yeah, so earlier on I made mention that if we are not having any of these binding rules between the consultant and the regulator, the commission will now seek to have to defend it by the other lawfulness of processing. That's where the legal obligation comes in. But as an organization, you should always confirm with the regulator what are the purposes of re-including this information. Because if there's a breach that happens now, you are the first point of contact the commission will come to. We'll do our investigation and know, do you have any agreement within the organization, within the agency, within the ministry? Because regardless of it being your regulator, you actually have to get a binding rules, corporate binding rules that will actually inform a structure that will actually inform that internally with these purposes of information, this is how we are going to process it. So first and foremost, if there's any breach of liability, the commission will come to you, the controller first. And if we are being backed under legal obligation, you have to evidence it. Data protection is all about evidencing it because there are systems out there that we say they are protecting us, they are safe, they are this, they are that, they are that. But then if you're not able to evidence that, you're not able to present it, whatever you are saying is baseless. So if you're having proof of whatever you are saying, any level of sharing, then we can actually see to it under a more understanding procedure and now take it from where it was to another procedure.
Okay, thank you for that. We have another question from Richmond Amwakon, who is saying that he had given his CV containing his data to FM, and subsequently he realized that another entity or another firm is using his CV. And so he wants to know what remedies there are for redress under the mandate of the commission, whether there's any like that.
Okay, so first, to approach this, the first question I'll ask the subject is before they were sending the information to the organization, did they first read their privacy policy on their website or any other application that they have? Did they consent to any other procedure? See, whether being a form application or whatever it is, mostly organizations hide those things in there where they will be sharing your information with other parties that they are affiliated with, but then they will not let you know. Just like the way you are also going to share the information with your regulator, you wouldn't identify it to the subject straightforward. So, per implied consent, the subject wouldn't be more informed on this information. That's why you are saying that you have to get your policies available. So on your website, on whatever medium, in person, website, in your organization, you always have to inform the data subject. So if you did read from their privacy statement on their website or on the form that was provided to them, you get to know that these things you checked or you approved or consented to it. So if you are not okay with it, you can request to them to take down that particular procedure where they are sharing the information to any affiliate third parties. When they are not informing you quickly on why they are sharing it or they are not responding to you at all, then you can escalate it as Section 31 is concerned. That you write to the commission that this is how your information is being processed and you are not okay with it. If there was not any consent form that has this requirement or these clauses on, you can write it to them. If they are delaying, you just write to the commission and we'll take action from there.
All right, thank you very much, Mr. Dia. I think this is very important, the mention of the privacy policy. I think a lot of the time, whenever we are signing up for things, websites and wherever, we do not necessarily read things like their privacy policies and their terms and conditions, which a lot of the time spells out how, our data is being processed. And so this is a very good reminder to everyone that please read uh, the privacy policies and the terms and conditions and any other associated documents regarding how data is being used if there's one. If not, like Mr. Diaz said, kindly write to the DPC and they'll be able to assist. We also have a question from Alice Apia, who is asking that now, as consultants, we are contracted by clients to provide services. And a lot of the time, as we've established, this entails collecting personal data. In some of the contracts with clients, it's indicated that all data collected as part of the service being provided by us, the consultants, belongs to the client. And so in this case, is the client also required to register with the commission, or just the registration of the consultant is satisfactory?
So the client here saying the information belongs to them, they have the intent of processing the personal data. So they have to register. And also, you, the consultant here, becomes a processor on behalf of that client that's actually requiring you to go for that information. So you as a consultant, you do not own that data. The data belongs to the client that you're having. So that client also needs to register. So for you to even take a contract from any client, you also have to do a due diligence on them. Are they having data protection compliance or certificate? Have they gone through the procedures to actually being approved by the commission? Even first, before you approve or take any contract with them. Because if there should be a case as such, two parties are actually going to be held liable. And within your contract being signed, the SLAs, the vendor assessment, you have to include data protection clauses that will cover you as a consultant when a breach should happen.
Okay, that is very, very well noted. Thank you for that. We also have a question from Ernest. He is saying that in a legal situation where other regulatory institutions might require individuals' data from the EPA or other regulators for legal processes, could there be a breach in giving out that data when it is not initially made known?
Please, can you kindly go over the question again, please?
Okay, he's asking that in a situation where you have other regulatory institutions, not the EPA, so aside the EPA, that may require data from the EPA or the data that we then share with the EPA for other regulatory purposes or other legal processes. Could there be a breach in that regard in giving out that data when it is not initially made known that such, a third regulator may be requesting that data?
Yes, it is. It is a breach because we are not informed on who else is actually going to have access to it. And the issue we are facing within the country is we are not having a more structured data governance framework. Because if this data governance framework is actually visible and implemented per industry standards, these frameworks are also going to hold us in binding conditions on how to share, how to process, how to disclose, and also how to inform in our decision when sharing information. So yes, it will be a breach. But then as time goes on, when the bill is being passed, all these governance will be structured and it's actually going to help in these particular gaps that we are facing at the moment.
Okay, thank you very much. We also have a question from Ivy Mensa, who is asking that in situations where communities or individuals that we consult have rather some low literacy levels, how can environmental practitioners truly obtain informed consent rather than just a verbal agreement? So whilst we wait for Mr. Dia to return, um, we would like to please keep your questions coming if you have any. We will be ending the webinar, or we'll try to end the webinar on time at 11:30. As usual, our previous webinars are up on our YouTube page, and so you can kindly find us at Set Ghana on YouTube to rewatch our past webinars if you missed them. We also this year did a live session in connection with the International Association for Impact Assessment Ghana. And so you can also check that out as well on our YouTube page. We'll also like to thank everyone again for joining. I see some familiar names on the call. And so thank you for sticking with us throughout our edition so far. And we will keep the webinars coming. Our next one would be next quarter. We will be sure to give you all the
Hello.
details and everything as
Hello,
we go
madam.
along. Yes, Mr. Dia. Okay,
So
you're welcome.
I've actually been summoned for another agent meeting, right? So I'll request
Okay,
that with all the questions, you actually let the participant know that we have a training procedure. We actually speak to bespoke awareness. So if they want more about this, they can actually write to the commission and we can take it from there. So please,
okay,
I apologize for that and I'll be taking my leave for now. So if they have any other questions, they can write it to, I'm putting in the training email so that they can contact them to know more about this.
okay. Yes, please. Thank you
All
very
right.
much.
Thank you all. All right, please.
Okay. Yes, so we apologize for this break in the webinar, but we have learned a whole lot from Mr. Dia today on how we can properly, professionally manage the data that we collect as environmental assessment practitioners or environmental management practitioners. And so, like Mr. Diaz said, if you have any more questions, kindly contact training at dataprotection.org.gh. He has kindly put the email in the chat. So please take note of that and kindly forward all your questions to Mr. Dia. I'm sure he will be more than happy to answer any questions you may have. If you also have questions regarding their registration process, you can also contact the email and they would be happy to assist. And yes, so we would like to bring today's session to a close. Again, apologies for the early closure, but please connect with us on LinkedIn at SET Ghana. Like I mentioned earlier, you can check out all of our past sessions on YouTube at SET Ghana, and also check out our website www.setghana.com for information about SET, the various services that we can provide, and also if there are any questions about our services and what we do, any questions about the SET perspective, you can also contact our email, info@setghana.com. Um, and so once again, I would like to thank everybody for joining today. And please watch out for details of our next edition, which we will be putting out on our LinkedIn page. So please follow and let's keep in touch. All right. Thank you very much and have a wonderful day.